Welcome back to the Law and Crime Network. My name is Bob Bianchi. I'm going to be taking it to 3 o'clock, and you know if it's Law and Crime, you know we got multiple fascinating trials that we're covering at any given point in time, and the Timothy Jones case is one of those cases. Okay, there you go. The defendant's half-sister indicating she does not want the defendant to die. Nothing surprising there. I've got with me Rossi, Latonia Hines, both prosecutors, former prosecutors, analysts. They've got it all. A great team to have handling these cases today. Latonia, let me start with you. I was in the chat room with our great chatters here at the Law and Crime Network, and they were looking at this video of the memorial as well as the church, and they were scratching their head, if you will, to a fault. Every single one of them said, how is this helping the defense? It's getting me mad. What do you think?
I guess they were trying to somewhat humanize the situation. I didn't think it was necessarily the best move, but what do you do as the defense? I've been a defense attorney as well. What do you do as a defense to say, justify and say that you need to give some compassion to a man who didn't give compassion to his 5 children? I don't know why they decided to use that video. I don't think it was necessarily helpful, but they've got to do what they've got to do.
You know, Gene, to Latonia's point there, the ex-wife, if you will, who's also lost all these kids, yesterday got on the stand and asked for a mercy for him because there had been too much loss in the family. Given the gravity of the kind of deaths here, 5 children snuffed away at his hands, the fact that they brought out that it may not have been a defense that he was insane at the time, but he has significant psychiatric illnesses. As a defense lawyer, can you piece or hobble something together, maybe to get one juror to say no to the death penalty?
Absolutely. And when I was in the U.S. Attorney's Office, we had the Zacarias Moussaoui case. He was the 20th hijacker for 9/11. And the jury was hung on death, 11-1 for death. So it only takes one. I have a theory. I'm trying to grab straws here as to why they put on that video. Number one, it shows a very emotional funeral, of course, and service. And in spite of that, the half-sister Jackie still wants him in her life and doesn't want death after all she went through at the funeral service and all that. The second thing is, and I don't know if they planned this, but when the video was played, the defendant was crying. He showed emotion. And I've seen death penalty cases. I've never done one. I've observed, quasi-supervised. When the defendant comes across as cold, calculating, that doesn't help. But he's got the tears and everything. I'm just grabbing straws as to why they did that.
Gene, you know, one thing you got to love about the Law and Crime Network, either between the hosts or the guests, you're not going to get more experience in a courtroom than we have here on this network. I have, in fact, tried death penalty cases. Latonia, Gene, I'm going to throw this to you. An argument that used to be used in the cases when I was prosecuting by the defense. It's an interesting one. Listen to it. It's a little bit of a curveball, but it's interesting. Let him live the rest of his life in jail in misery, knowing what it was he did in that horrible, hateful place. Don't end it early for him and give him an escape. What do you think, Latonia?
Yeah, I mean, of course, that's obviously one of those defenses that are used. However, if you think about how the death penalty came about, a little bit of this common law, and if you were to go into morality, I think sometimes the death penalty is truly what it says. It's punishment. It's almost the closest thing you get for an eye type of thing. And so that him being able to live out his life and be able to live and eat and all these other things, as a prosecutor, I would say that's not sufficient. That's not sufficient recompense for 5 children who were killed by at the hand of their own father in such a gruesome way. So I would say that. The thing also I would say too about this, Robert, that this case reminds me, you guys remember Andrea Yates? Andrea Yates, killed her 5 kids, but the difference in that case is that, at first it was a capital murder case, she was convicted, and then they didn't find for the death penalty, but they ultimately overturned that case. But there was more evidence to the fact that there was something mentally wrong with Andrea Yates. There was something more there. And I don't think you have that here in this case.
I don't know, Gene.
So that's what I think.
Right. Gene, I mean, there is documented mental illness here. There is a diagnosis. And let me go to a more common place that maybe a jury would understand. I'm just making arguments that I would try to come up with or I'd be concerned about as a prosecutor, that just the sheer nature of what he did alone yells and speaks of somebody who's insane, or maybe not as to a legal defense, but a reason to spare his life. Yes?
Oh, absolutely. He drove around for 9 days, I think it was, with his deceased children. That is just, that doesn't show a person who's with it. John Chuck, that was calculated. He threw her over the bridge and he scooted. But I want to go to what Latonia said. She's right that Andrea Yates, and I remember watching just clips of that, when you saw her in the courtroom, you could just look at her and say, something's not right. But I want to add this to your first point about serving time in a prison and for the rest of your life, let him think about his heinous crime. One of the arguments that saved Zacarias Moussaoui 11-1 for death is, I remember the defense attorney said, he's going to be in a maximum security prison for the rest of his life. That's not a walk in the park. But number two, don't make him a martyr. He wants to be a martyr. Don't give him that gift.
Yeah, excellent point. I remember that very well. It was a very interesting argument made there. Gene, Latonia, you guys are the best. Only here at the Law and Crime Network are you going to get these multiple trials of such great fascination. I'm curious in the chat room, what do you think? I mean, are the defense got a possibility at life, or is this guy going down for the murder of his 5 children? We're going to take a quick break. We'll be right back. All right, there's the defense team in the Winslow case giving a press conference after the verdict. Gene, we thought very highly of these defense lawyers, but the fact of the matter is, and I just want to break this down a little bit, and hopefully we'll be able to get a graphic up there for our audience to take a look at. With respect to Jane Doe 1, as you can see in the top there was a hung jury on each of those counts. With regard to Jane Doe 2, you see there that he did get convicted of one count that carries up to 8 years in prison and were hung on the second count. And then there was a guilty on the third count, which carries up to 6 months. It's kind of a small sentence. Jane Doe 4 hung on both counts, guilty 10-8, and as far as I'm understanding the split. And on the last Jane Doe 5, guilty with a 6-month lewd conduct, not guilty on another offense, and hung on the rest. So let's go to this. Let's break this down, Gene. What the lawyer said is true. He did get out of the life sentence pieces of this, but they can be retried by the prosecution. We had a long discussion about this before I came on air at the Law and Crime Network when we were discussing it. Do the prosecutors or the defense lawyers come forward and say, look, you got 8 years or up to 8 years on that one count. We'll give you a plea with respect to the rest of the victims in the case so that the victims each have their day in court, if you will. You run them concurrent and we resolve the whole thing, no appeals, we move on? Or do you fight it out? Whereas as a prosecutor, I could see myself saying, you know what? I'll put the B team in on the rest of the counts because I got them for up to 8 years on the rest of them. Then the other case is just gravy, whether we win it or lose it. Thoughts, Gene?
I would try to work out a deal as soon as possible if I'm a prosecutor. And if I'm a defense attorney, I would take that. Nobody wants to retry
Please keep
a case.
it turned off.
As I've said before, retrying a case is like putting on a wet bathing suit. It's miserable. And you have litigation hazards, both sides. I do want to say this. My rule of thumb was if the split is 9-3, 10-2, or 11-1 for guilt, I'm going to retry. If it's 7-5, maybe even 8-4, I'm going to think twice. I've had the whole range. And I didn't like retrials unless you're facing a murder charge or something like that. The punchline is this: they declare victory and go home. The prosecution got 4 guilties. They got some significant potential time. You made your point, move on.
Latonia, same question to you. And again, I'm going back to my old days when I would sit there in the office making these calls. I could definitely hear myself saying, well, if they want to be reasonable, we could work it out. The victims don't have to take the stand again. There's going to be a plea with respect to each of the offenses, so they got their day in court. But I could also see the other Bob Bianchi that could sit there and say, you know what, this guy hasn't accepted responsibility. He thinks who the heck he is. And you know what, I'm going to go get the sentencing on the 4 counts he was found guilty, seek up to 8 years in jail, and I'm going to retry the rest of those counts. If I lose it, I lose it. So be it. They got to give me something, or I'd rather lose it in court.
Right, and I understand that as well. I mean, I think as prosecutors, we sometimes feel like that, especially when you truly believe that the defendant is guilty and that he should be held accountable. But we have a situation much like what Gene is talking about, and I think it would be one of those considerations, which is that you've got these victims. Victim number 1 is obviously a fragile victim in itself, and number 4. And do you want to have to make them go back through all of this again? What you have gotten from this is that he is a convicted sex offender. He's got that convicted rapist, sex offender. For the community, wherever he goes, whenever he gets out, that is something that he will have to declare. So you have that out there for it. But I think you would try to work for some type of resolution or some type of plea deal in this case at this point, because just because he does even accept a plea, or even if he is found guilty again of these counts, that doesn't mean that he's going to accept what he did. I mean, he obviously has some serious issues.
Well, the best thing that can happen for the prosecution, if you will, would be the defense that continues to say, we're going forward with it, we're going to appeal it, and keep the gloves off, because then I really don't have to make a decision as a prosecutor. Guys, right. I want to bring up this point with you, because I hear a lot about, and certainly for sure it exists, disparity in sentencing that exists. A lot of times it's attributed to whether it's a minority community or people who have money and those who don't have money. But I think that this case illustrates the kind of negotiation and thought process that goes in with prosecutors with respect to, like, well, how much is enough? Is it better to spare the victims, as you guys are saying, and lock this in so that there's no appeals in 8 years? And as you put, Latonia, he's going to be a registered sex offender. And I think that it's a lot of times because we could have differing opinions about what's appropriate on a case-by-case basis, that you see such wild differences with cases that are seemingly similar. Gene?
Absolutely. And I wanted to follow up with what Latonia said. Making the victims go back and testify a second time. Every witness I've called in a retrial, they're never the same the second time. They're exhausted. They don't have that passion and emotion that they had in the first trial. That's just the nature of testifying. But I just want to be clear, for Jane Doe 1, he was found guilty of rape. Am I correct?
I am not seeing that on the sheet. That was Jane Doe 2. I'm sorry,
Jane Doe 2.
It's
rape.
Gene, right. I don't have a forcible rape on Jane Doe 2. I understand was a guilty, facing up to 8 years in prison.
Got it. What I would do if a prosecutor, and this is the Bob Bianchi and me, I would say, listen, waive appeal, accept responsibility for Jane Doe 2, the rape, and the other charges you were found guilty of. We will not retry the case. And if defense attorneys don't take that offer, and because it's an 8-year cap, if they don't take that offer, then Winslow is driving a train, and then he just wants to go to trial and spend his money and fight everything. But I would make that offer, and I'd say, listen, if you reject it, we're going to retry every count.
Right. That's exactly the offer that I think that I would. This is what we discussed before. You face up to 8. I mean, you can maybe make an argument to the judge for something less if that's allowed in that particular state. Yes. But we're seeking the 8, so you got some leeway there. It wraps it all up in a bow. Otherwise, we're going to be looking for that life sentence. It really does put a difficult thing into the defense's hands. Gene, I wanted to say one last point. You mentioned it before, which is also true. Not only you're putting the victims on a second time, but the case never gets better because now the defense has transcripts by which they can cross-examine these lay witnesses, making the cross-examination probably more effective for the defense. Guys, I love having your insights here, and only like a case like this on the Law&Crime Network can we get such great experience like Gene and Latonia. We're going to do some business here, and we will be back with more Law and Crime.